Good day to you and welcome to another Paddocks Club tutorial. Today we're going to talk about how rules apply to schemes. This is a video designed for owners and trustees as well as managing agents. Schemes registered before 1st of June 1988, let's look at those first, and that date is important because it's the effective date of the current Sectional Titles Act number 95 of 1986. At first, all schemes registered before that date had Schedule 1 and 2 rules under the old Act 66 of 1971. Usually, but not always, those Schedule 1 and 2 rules were completely replaced soon after the body corporate was brought into existence. Otherwise, purchasers couldn't get mortgage finance. If on the effective date those rules had not been changed, then the situation was very simple. The prescribed management and conduct rules simply replaced them entirely. That, as I say, was a bit unusual, as was more usual if they had changed. Then there were a few categories. Firstly, some types of rules were protected. Rules that created exclusive use rights or gave other vested rights to owners, those came through into the new rules. Other existing rules were compared, at least at a metaphoric level, to the prescribed management rules. And where they had exactly the same effect, the old rules remained. But if they were different, then the prescribed management rules dealing with the same subject replaced the pre-existing rule. If the prescribed management rules made a provision different or in addition to what was in the existing rules, then that was added to the scheme's rules. So on the 1st of June 1988, the rules of a pre-existing scheme were made up of the protected provisions, the prior rules that had the same effect as the prescribed management rules, and prior rules that weren't contrary to either the prescribed management rules or the Act. And in addition, they were supplemented by those prescribed management rules which dealt differently with issues already dealt with in the prior rules, and those parts of the prescribed management rules that dealt with matters that weren't at all dealt with in the prior rules. The main difficulty here was to figure out when something was irreconcilable with the prescribed management rules, because that's fundamentally a legal decision. The easiest approach, which I recommend to you, is that you say, does it deal with an issue covered by the prescribed management rules, but not have the same effect? If that is the case, then it was automatically replaced on the 1st of June 1988. Let's move on to schemes registered after the 1st of June 1988. Well, you start off by checking the Section 11.3b conveyancer certificate that was lodged when the scheme was registered, and to see what rules were substituted or added by the developer. Look also for any other Form V that's been put into the deeds registry since then, and update the copy that the body corporate has of the rules, also including the updates to the prescribed management rules that have happened every year or so over the last 10 years at least. Let's look at all of that. It was quite a lot, so I'm going to give it to you from a slightly different perspective, but it's the same material. I'm just saying it in a different way. The prescribed management rules, as amended from time to time, apply to all schemes registered after 1st June 1988, to the extent that they haven't been substituted by the developer or by the body corporate. When we look at schemes registered before the 1st of June 1988, they started out with the Schedule 1 and 2 rules under the old Act, which were almost always substituted entirely with new rules soon after the body corporate came into being. These rules were then on the 1st of June 1988, in terms of Section 60 of the current Act, amended by the currently prescribed management rules to the extent that these were irreconcilable with those provisions. Section 60 of the Act did and does not require a scheme to produce a new schedule, a new document with all the rules showing the old ones thrown out and the new ones put in, but in many schemes it's not obvious from the documents that the trustees work with exactly how this thing happened. What do you do about it, and what do you do specifically if you're not sure? Trustees must know and must be confident that they know the content of the scheme rules. They must know what is in the deeds registry files for their particular scheme. If these are incomplete or suspect, then they must get legal advice to find out what rules apply to their scheme. And they must either learn how to assess the content and changes as they are made each year, or pay a qualified person to do the job and confirm what rules apply. Thank you very much for watching this video tutorial. I look forward to chatting to you in the forum.